Good afternoon, everyone. This is Mark Waletsky. I'm an attorney at Holland & Hart, and thank you all for joining us today. I know it's short notice, but we were hoping that this would be helpful to you, as I'm sure you, like many of us, are struggling to figure out, what do we do now? What do employers do now that the new overtime rule that was supposed to go into effect today has been put on hold? And just a little bit about my background. I have been practicing labor and employment law for nearly 20 years now. I focus on wage and hour issues regularly, both in terms of litigating these issues in court, defending employers, and advising employers on a regular basis on how to stay compliant with the rules and with rule changes. For those of you who might have joined a little bit late, just a reminder, if you have questions, please feel free to type your question in on the lower right hand of your screen. There should be a little box there for you to enter into a question, and I will do my best to answer that. I may not answer it immediately, but I will definitely do my best to get to any and all questions that you might have. And what I planned to do today was to talk briefly about some of the background and how we got here. You'll see some slides as we go through about the new regulations and the tests, but the real emphasis and really where I plan to focus was what to expect and options for moving forward for employers, because I think that's the biggest struggle right now, given where we're at. So the question is, as you'll see on this slide, well, what just happened? And I'm sure as all of you know by now, what happened is that on November 22nd, a federal district court judge granted a nationwide preliminary injunction that stopped the Department of Labor's, the DOL's, new overtime rule from going into effect as it had been scheduled to do on December 1, 2016. So that's how we got here. That lawsuit was filed by a number of states, as well as some chambers of commerce, and their goal was to put a stop to these new regulations from going into effect, and that's exactly what the court just did. And the court reasoned, this is how the court got there. It said that the Fair Labor Standards Act describes the so-called white-collar exemptions, those exemptions for professionals, for administrators, for executives. It describes those exemptions by duties, not by a salary level. And it's clear that the Fair Labor Standards Act delegates rulemaking authority to the Department of Labor. There's no question about that. But the court said, and this is the key, that by raising the salary level so high, the Department of Labor basically supplanted or superseded the duties test. And the court said, that's just too far. That exceeds the Department of Labor's authority. So that's how the court got to the point of saying, no, I think these new rules are unlawful, and I'm going to put them on hold nationwide. Now, it's important to note that the court said it's not making a general statement, about the salary level test for the so-called EAP exemptions. I know I apologize in advance. Sometimes these exemptions are referred to as the white-collar exemptions. The court in its ruling referred to these exemptions as the EAP, the executive, administrative, and professional exemptions. It's the same thing. And as all of you, I'm sure, know, there's been a salary test essentially, not quite forever, but for all the time that we've been dealing with these rules and these exemptions, there has been a duties requirement in order to meet the exemption and a minimum salary requirement for these exemptions. And the court said, hey, I just want to make clear, I'm not saying that you can't have a salary test at all. I'm just saying that the salary tests under the new regulations go too far. Now, I think that may be a tough piece of reasoning to uphold, but that's the reasoning that the court employed, is simply that the new test, which essentially doubled the salary basis test, just basically took over. And it basically meant to the court that it didn't really matter whether you were performing legitimate administrative or executive or professional duties, because if you didn't meet that salary threshold, you were non-exempt. In other words, you were overtime eligible. So again, I don't want to spend a lot of time on the new rule, because I think you were all familiar with it, and it's, of course, on hold. But I did just want to go through it briefly. The new rule, as I mentioned, close to doubled that salary test from $455 a week, or $23,000 and some change a year, to nearly $47,500 a year, or $913 per week. The highly compensated employees jumped from $100,000 to $134,000, and importantly, under the new rule, if it had gone into effect, those salary thresholds would have automatically increased every 3 years without any need to go through any rulemaking process. So that was going to be a significant change, and I know a change that so many of our clients and so many employers throughout the country were really wrestling with. I already mentioned the automatic updates. This slide really just talks about the nature of those updates, and the updates were first going to occur on August 1 of, I'm sorry, they were going to be announced as of August 1, 2019, but to go into effect January 1 of 2020. Another key provision of the new rule, which is now on hold, is that bonuses, incentive payments, and commissions, at least up to 10% of the standard, could make up at least up to 10% of the standard salary threshold of $47,476. Those payments must have been made on at least a quarterly basis. This was actually one of those better parts of the new rule, and that would have given a little bit of flexibility, but this piece is now, like the other aspects of the new rule, on hold. So again, I have the slide up here, and hopefully it's just helpful for you to have it as a resource now that we're going back to, at least for the time being, the existing white-collar exemptions. all of these are the same in the sense that these folks must be paid on a salary basis, which means you're not just looking at a 40-hour work week and converting what those hours would amount to at a certain level to a set salary. The salary stays the same whether they work 30 or 35 hours or 45 or 50 hours. The salary level test right now, in light of the injunction, is still at $455 per week, or $23,660 per year. And the duties tests remain the same. Those were not going to be changed under the new rule. So those are the same as they have been since they were last changed in 2004. The highly compensated employee exemption is still at $100,000. The employee's primary duty must still include performing office or non-manual work, and the employee must customarily and regularly perform at least one of the exempt duties or responsibilities of the white-collar exemptions, so the executive, administrative, or professional. I often refer to the highly compensated employee as you have a watered-down duties test. It's not non-existent, but it definitely is watered down because you don't have to meet all of the duties of any of those other exemptions. The other common exemptions remain unchanged. The computer employees and outside sales employees, those still remain the same. And unfortunately, they still do not have a kind of standard white-collar exemption, at least for inside sales. There are other exemptions that may apply for that, but if you have a lot of inside sales folks separate and apart from our discussion today, just be aware that shoehorning them into an exemption can be challenging. So, getting to kind of the meat of it, what's next? What can happen next? Well, the first bullet that we did, and this was done a couple days ago, was will the Department of Labor appeal the preliminary injunction ruling? We now know the answer as of this morning. The answer is yes. The Department of Labor filed an appeal of the preliminary injunction ruling with the Fifth Circuit Court of Appeals. Now, keep in mind, the Fifth Circuit Court of Appeals is known as a more conservative circuit, and they have, at least in the recent past, also invalidated at least one other of the Obama administration's rulings along the immigration front. So we'll have to see what happens with that, but to the extent people were wondering, and I was one of them, whether the Department of Labor would appeal, they will. Now, what exactly does that mean? I'm sure a number of you are wondering, well, does that mean these rules, immediately go back into effect since they appealed? The answer is not quite. So there's a couple unknowns, even though the Department of Labor is challenging this district court's decision to enjoin the new rule. First, appeals can take a very long time. It can take a year or more for an appeal to wind its way through just the Fifth Circuit Court of Appeals, let alone the U.S. Supreme Court, which is where this decision could end up. Now, the Department of Labor can ask for an expedited appeal, and that's essentially what what the states did when they asked for a preliminary injunction in the district court is they basically said to the court, listen, we need a ruling on this quickly because these rules are going into effect on December 1, and we want the court to rule on this quickly. So the Department of Labor can essentially do the same thing at the Fifth Circuit Court of Appeals and can ask for expedited briefing on this matter and say, hey, this is an important issue. It impacts employers and workers nationwide. We would really like the court to put this on an expedited briefing schedule. There is no trial at the appellate level, and this is really just a matter of filing written arguments with the court along with a oral argument, which is lawyers making their arguments, which will last anywhere between 15 to 30 minutes per side, typically, unless they're granted more time. So they could do that, and that would certainly shorten the time frame for an appeal. But meanwhile, those rules, the new rule, remains on hold unless the Department of Labor convinces either the district court or the Fifth Circuit to essentially lift that injunction pending the appeal. Now, I don't know if the Department of Labor is going to ask for an expedited ruling, although I anticipate they will. And I don't know whether the Department of Labor will ask to essentially lift the injunction pending the appeal at the district court or at the Fifth Circuit. I anticipate it might, and this is just a guess on my part. I'd have to say I would not bet on either the district court or the Fifth Circuit lifting that injunction pending the appeal. In other words, my best guess at this stage is that the rule is going to stay on hold pending the outcome of an appeal to the Fifth Circuit. And we don't know how long that will take, but I think it's, we're looking at, it's certainly not going to be a matter of days or even a few weeks. We're more likely looking at least a month or two and possibly a little longer than that. The other question that's out there is that the business groups that separately sued to stop the rule from going into effect had asked for the court to grant summary judgment, which just means they asked the district court to rule without a trial that the new rule is unlawful. And that would not be a preliminary decision. That would be a, if granted, would be a final appealable decision. Again, I don't know what the district court will do, but my hunch and guess is that the court may put that issue on hold pending the outcome of the appeal, because if the Fifth Circuit, however the Fifth Circuit rules, it will impact the business group's motion for summary judgment. So we've got some interesting times here and some open questions, and we don't quite know the answers yet. And of course, the big unknown is the Trump administration. And what will the Trump administration do once the president-elect becomes the president? Now, I think it's fair to say that at least one option that the Trump administration has is to direct the Department of Labor to withdraw the appeal. That assumes that the Fifth Circuit will not have ruled by the time the Trump administration would direct the Department of Labor to do that. And I think that's a real possibility. But we just don't know yet what is going to happen once the administration takes office They obviously are working on a lot of different things. This has certainly gained a lot of attention in the past couple of weeks, and even though the press has been primarily focused on what the Trump administration is going to do with the Affordable Care Act or Obamacare, I do think that there is at least a decent chance that the Trump administration will direct the Department of Labor to withdraw the appeal. Now, if the Department of Labor withdraws the appeal, what happens? Well, the preliminary injunction could be made permanent at that point, which means the new rule will be on hold permanently, or at least unless and until the Department of Labor or Congress acts to come up with some new rule on this subject. And I'm not even going to hazard a guess as to when something like that could occur. That could literally be years. It's very hard to know what would happen if the rule gets put on permanent hold, because the Department of Labor then would either have to go back to the drawing board, or under the new administration could say, we have no interest in changing these rules whatsoever. And so it's really hard to know what might happen once the Trump administration starts really focusing on this issue in January, or whenever the administration starts looking at the issue. So a lot of unknowns right now, which is never great for employers, especially when you're talking about how you're supposed to pay employees. So that brings us to really the main question here is, well, what should we do? Because I know from talking to friends, from talking to colleagues, from talking to clients especially, a lot of you have been struggling with trying to come into compliance with this new rule, not just for a matter of days or weeks, but literally months. For those in the hospitality industry, in retail or nonprofits, I've heard from a lot of those folks who simply, raising people's salaries was not an easy or great option, and dealing with budget constraints was similarly a very, very tough problem, because the salary threshold was being essentially doubled. So I know that a lot of people struggled with how do we comply and what do we do, and the answer to the question, what should we do now, is it really depends on your workforce, where you're at with making changes, and what type of other non-legal issues you might have in the background. So I know the it depends answer is never satisfying, to me included. So I want to run through some different options that employers have. And as we're running through these, if there are options that I haven't talked about, feel free to type in a question or make a suggestion on other items. I know it's hard to make webinars interactive, but feel free, because this is a tough and challenging issue for employers literally around the country. So one option here is, if the duties test is not clearly met, classify these individuals as non-exempt, in other words, overtime eligible. If you had people who were on the bubble already, and you were thinking, okay, they were making, 27, 28, 29,000. We never really felt all that comfortable with where they were in terms of the duties. You might want to look at that and reclassify them as non-exempt anyway, because if they don't clearly and unmistakably meet the duties test, then they are not exempt from overtime. And let me emphasize, I'm not just making up the clearly and unmistakably language. That is wording that the courts use, that the Department of Labor uses. The courts and the Department of Labor construe these exemptions narrowly, and if someone does not clearly and unmistakably fit the exemption, then keeping them classified as exempt simply because the salary didn't go up means that you are just continuing to have some level of risk to your organization. Now, changing someone over creates its own risk. So beware that, if you change someone over and you tell them, well, we're changing you over even though the rule didn't change because you really don't clearly and unmistakably meet the duties test, and so we just thought this was best. Well, if you're that candid with your employees, just beware that they could easily go to a lawyer and make a claim, or go to the Department of Labor and say, well, if I don't meet the duties test now, then I haven't met the duties test for the last 2 or 3 years. And so I'm entitled to back overtime pay and liquidated damages, which you can get under the Fair Labor Standards Act, which essentially doubles the damages. So this is always a very touchy and delicate situation if you are going to reclassify someone, even though the new rule did not come into effect. There's no, again, one-size-fits-all, but one thing you can certainly do is to reclassify people and say, we were far enough down the road on this, and we just feel like it makes sense in light of the organization. I would never suggest, and I'm not suggesting, that anyone lie or fib to their employees. On the other hand, you don't have to give them a statement that they will be able to use against you if they file a claim with the Department of Labor or go to court. So, but that is certainly one option that is always available and certainly available now. Another exemption is just maintaining the status quo. Don't do anything. Don't make any changes. You're not required to raise any salary levels. We will continue to monitor the legal status of the rule. You should as well, and that is definitely an option. Obviously, if you have folks, as I mentioned before, who are kind of on the bubble, you've got some risk, but you can certainly wait and just kind of wait and see what happens and watch, because there's no question something's going to happen. We don't know what it is, and we can't predict necessarily what it will be, but we know that either the Fifth Circuit Court of Appeals is going to make a ruling, the Trump administration will get involved, the Supreme Court may get involved, but in one way or another, employers will be getting more guidance on this issue, and it will we'll just have to wait and see. Now, at least one person has asked, well, okay, so let's say the Fifth Circuit takes the appeal on an expedited basis, the Trump administration declines to get involved, and the Fifth Circuit Court of Appeals says, you know what, we don't agree with the district court, and so we're going to reverse the district court. We think that this new rule is valid and legitimate rulemaking authority under the Fair Labor Standards Act, and we're going to defer to the Department of Labor. Does that mean that the next day you all have to make these changes? No, you'll have some time, probably not months and months and months, but I would not expect the Department of Labor to say, yeah, we expect everyone to be in compliance day one. In addition, the states, the business groups could appeal that ruling to the U.S. Supreme Court, and the U.S. Supreme Court could ultimately take the case. So I'm not expecting a situation where employers will have to make massive changes day one following a court decision, but I do think it's worth continuing to monitor these cases, because if the rulings go the other way, employers may have to make some changes, and they may want to make them fairly quickly, all things considered. So the next question that's come up with a number of clients is, well, we've already promised a raise, and this has happened, and I imagine there's a number of people on the phone who are with organizations where this has occurred, because you had individuals who were very, very close to the new salary threshold, but they were just under it. And so for those folks who were doing everything they needed to get ready, you might have already had conversations with your employees and said, okay, there's a new rule that's going into effect. You're exempt. We believe you're exempt, but your salary doesn't meet the new threshold under the new rule. So we will go ahead and give you $1,000 or whatever amount the raise is to make sure they stay exempt from overtime. And for a lot of people, that made a lot of sense, because the overtime cost associated with those individuals, especially those who are making close to the new salary threshold of over $47,000 a year, could have been very, very significant. So if you've already promised a raise, do you have to go through with it if it hasn't gone into effect yet? The answer is, well, you're not required to do that under the Fair Labor Standards Act. The Fair Labor Standards Act doesn't mandate that you go through with a promised raise. But all things being equal, I'd be very, very concerned and cautious about revoking a promised raise, because, you know, if nothing else, you're going to have a morale issue on your hands. If someone was promised and expecting a raise, even if it's relatively small, that's going to create a morale issue. You may have claims from employees who say under state law, not the Fair Labor Standards Act, but just state law, hey, I think we had an agreement. I have an email from you. I relied on this. I maybe turned down another opportunity because I thought I was going to get a raise, and now you're obligated. And do you really want to get into a lawsuit with one or more employees over what is likely, I don't know this for sure for all of you, but what's likely a fairly small amount when you're looking at the amount of the raise versus the potential costs of litigation, which even with a small amount at issue, litigation can be very expensive, not to mention time-consuming. You've also got, in addition to that issue and morale, just the goodwill that you could generate by saying, you know what, the rule didn't go into effect. We don't know that we're even required to do this, but we're going to go ahead and do it anyway. That could very well generate some goodwill for you and your organization, especially if you've got some key people that you want to keep anyway. And lastly, is there a competitive advantage to you if you go through with it and a competitor maybe does not? if you've got a tight labor pool for folks who are paid at this level, if you've got some strong competition over that labor pool, then going forward with that, even if your competitors do not, may pay off dividends in ways that are maybe hard to see initially, but it may put you at a competitive advantage. And the flip side of that is if you don't do it and your competitor does, do you lose someone who you consider to be valuable over $1,000 or $2,000 annually? Those are the types of things that I would recommend considering before pulling back or not instituting a raise, excuse me, to those who you have already promised a raise to. Now, obviously, if you had not communicated that raise to any employee, then putting that on hold does not raise those same issues, because if the individuals had no idea that was even coming, then simply putting that on hold pending the outcome of the court cases or the Trump administration taking action really makes, I think, a lot more sense, because you just don't have these other issues out there. Now, another question is, well, what do we do if we've already converted employees to non-exempt status? That's a tough situation as well, because can you convert people back? Sure. There's nothing unlawful about that, so long as they meet the current requirements for exempt status under either the white-collar exemptions, the executive, the administrative, the professional, or one of the other exemptions. So there's nothing technically illegal or wrong about doing that. But again, kind of the soft issue is, well, how are the employees going to react to that? Now, my experience has been that some employees may be thrilled to know that they do not have to keep track of their time, that they do not have to, quote unquote, punch in and punch out at the beginning and end of the day and for a lunch break. Some employees look at being classified as non-exempt or overtime eligible as a demotion, even though that's not true, but they started out maybe in a lower tier role and have moved up to an exempt role. So I would consider, before switching people back, what kind of reaction you think you're going to get from folks. Excuse me, and consider as well, as part of that, if employees had said, I always felt like I was non-exempt anyway, and I really am counting on this overtime pay, that's a big difference. Or if you told them, well, you're going to be non-exempt, we're changing your pay, you'll be about the same, you might make more, in order to kind of convince them that this was not as bad as they may have thought it was. Employees may have relied on those statements. And so converting them back could, again, create some problems, create some issues that aren't technically legal, but certainly might impact your workforce and how you deal with these individuals. So some basic reminders of what you can do now, and these really have kind of always been true, or they're just basic things, but I think they're good reminders to think about and to keep in mind. One is, you can always make sure exempt employees work a set schedule. Even if they're exempt, it doesn't mean that you can't say, hey, we expect you to be here during core hours. So if that was one of those issues that was driving you to, re-examine people's status as exempt or non-exempt, just be aware that you can do that. Just keep in mind that if you ask someone to work a set schedule and you change their pay whenever that schedule changes, then that is a problem, because then they are likely not being paid on a salary basis. Updating job descriptions. If you've gone ahead and made changes, you should really update your job descriptions to make sure they track whatever changes you've made. And if you created new job descriptions that you were ready to roll out, I would make sure to put those on hold and communicate with folks that that those should be put on hold. And I see that we have a question, and let me just jump to that, because this is it's a good question. And the question is, I'm confused on how to determine if someone meets the exemption that the employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. What are considered matters of significance? So this is a great question if you've got folks who are on the bubble or you weren't sure if they really meet the duties test to begin with. So that quote of exercising discretion and independent judgment with respect to matters of significance is associated with the administrative exemption. And I will tell you, and I don't think this is going too far, everyone's confused by that, that sentence. Courts struggle with it, lawyers struggle with it, clients struggle with it. I'm going to give you my best take on an answer. First of all, the administrative exemption most clearly applies to what I'll call back office functions, human resources, payroll, things of that nature. Now, if you have someone who is administering payroll, for example, and works fairly independently but reports up 2 or 3 levels, even though that person is doing the typical back office functions, they probably are not exercising independent judgment with respect to matters of significance. They are inputting information, they are very important to your system, but they are primarily crunching data. And the same may be true, for example, if you have multi-level human resources department where you have, for maybe, just to pull an example, a recruiter who really doesn't have a lot of discretion in hiring, but simply handles the screening and advertising process. That is really not handling matters of significance or exercising a lot of discretion or independent judgment. But if you have someone who, for example, in human resources is developing policies and procedures for the organization and maybe isn't the final say, but gets to develop those policies and procedures, that tends to be a matter of significance because it impacts a large portion of the workforce or maybe all of the workforce, and it's significant to the workforce. Or you have someone who is not just crunching data in payroll, but is developing budgets and communicating budgets and is responsible for ensuring that people stay to budget or maintain a budget. That is something that is, there's discretion, there's judgment, and that's a matter of significance. So someone who, for example, operates independently and consistently is required to order or reorder supplies, that is likely not the type of discretion and judgment that would satisfy this test, because they're typically looking at what past orders are. They typically can't deviate too much from what they're ordering, and maybe they're ordering, new pencils or soft drinks or paper or supplies. That's not really it. Someone who has more opportunity to say, you know what, I'm looking at how we're ordering these supplies from all these vendors, and I think we can get a better deal if we renegotiate, and I'm going to try to renegotiate that. That's the type of discretion and independent judgment with respect to a matter of significance that would more typically satisfy that test. But that is a very tough area. So just be aware, if you have folks who are in the administrative exemption and you're going to keep them there, and they are not in the traditional kind of back office function, that doesn't mean they won't qualify, but it does mean you'll want to look pretty carefully at that exemption. So going back to some reminders, and I'm just kind of going clockwise around this slide. Communicate with employees. That's one of those keys, and hopefully that's come through this afternoon. Keeping them informed is going to go a long way to avoiding a dispute, avoiding a claim, or avoiding a lawsuit, no matter what you do. And if you make changes, or if you decide to not roll out changes that you had communicated to employees, my suggestion is make sure that you have a standard, I guess, outline or points that people who are going to be communicating with employees can refer to. Talk to your supervisors so that they know if they get questions how to handle those. Consider developing an FAQ, and it could be very short. It could be, a typical question and answer could be, well, why aren't you making this change? Why am I not changing to exempt status? And the answer could be, because you meet the current definition of exempt status, and the new rule that was supposed to go into effect has been delayed. Another one could be, well, when are we going to know more about the changes? And again, and I'm just kind of throwing these out there, but an answer could be, as soon as we have more information from the courts, Congress, or the new administration, we will be working with that and letting you know as soon as possible. But those are kinds of things you can't tell someone we'll have a new decision in 6 months because no one knows whether that's true or not. But making sure that the people on the ground, and by that I mean the supervisors who are going to be interacting with the employees on a day-to-day basis, making sure that they know how to respond to questions, I think is always critical and is certainly true in this case as well, whether you make changes or don't, if some changes had been communicated to employees. And finally, a reminder to make sure to update your payroll system and your personnel, again, with appropriate information, because if you're ever audited, if payroll hasn't updated its records and people are listed as exempt because they were anticipating that happening in your HRIS system was changed just ahead of the new rule going into effect, I would say just make sure you've looked at that and made that change to your system. And I know these are these are not easy issues. We know that you all are working on these and struggling with them, and immediately after the court decision, I talked to one friend who said I didn't know whether to laugh or cry, so I did a little bit of both. And I think that was a great statement and probably a fair one, as it reflects what a lot of you have struggled with. And we've got another question, and if you have questions, now is the time. Feel free to send them in, and I'm happy to deal with those. So this question is, if audited, what is the DOL going to look at to clearly and unmistakably prove if an employee meets the test? A job description, an employee interview, the answer is yes and yes. The Department of Labor will not simply look at someone's job title as set forth in a job description. The Department of Labor typically is going to look at the job description and want to talk to employees who are in that role to see what they do. And I can tell you, if you haven't been through one of these before, the job descriptions, if those don't match what your employees say they do, that can be a real problem. Sometimes that happens because, job description simply hasn't been updated for many years. There's been a merger and acquisition or something along those lines. Sometimes a person's job duties have changed to the point where they're clearly exempt, but their job description just was not updated, and that can be a problem. So it's another reason to make sure that your job descriptions are updated at least somewhat regularly, or at least reviewed, so that they match accurately what your employees are actually doing day to day on the job. And obviously, I want to thank everyone for taking the time. I'm going to stay on the line if there's any more questions for another 5 minutes or so here. Like I said, I'm more than happy to answer your questions, but I want to say thank you to everyone for participating, and we'll continue to monitor the developments and send out alerts as appropriate based on any new court decisions or changes in the law. I just got a question about downloading the presentation or having it emailed. For anyone who had trouble logging in or missed a portion, we will be sending out the slides to all of those who participated, and obviously feel free to share those with your HR team. If you don't, for whatever reason, get those slides in the next day or two here, feel free to email me or contact us, and we'll make sure that you get that information. We also have a question, what's the best online resource to stay updated in real time on the movement of the DOL rule? Of course, I have to give a plug to our own blog because we are updating our blog regularly on this, and so if you go to our website, it's you can get a link there, or it's www.employerslawyersblog.com, and that will get you there as well. Other than that, I'm not sure, because we're making sure to stay on top of it, but hopefully that will get you what you need. And you can sign up if you want on our blog to get automatic updates, and that way whenever we post something, you'll get an update. All right, I'm going to sign off. Thank you. Oh, there's one more question. Let's see. Could it be argued that if a person is the database manager for a membership association that is a primary duty related to management or general business operations to meet the admin exemption? Maybe. It's really hard to give advice on those types of questions without having a lot more information about what exactly they're doing, and whether that meets the test. If they're a database manager, that's a definite maybe. I wouldn't say definitely no, but I'd say that's one where I think you ought to work with your legal counsel to really look at that one pretty carefully. Well, again, thank you for everyone for attending. I'm going to go ahead and sign off. I hope everyone has a good rest of their afternoon. And if we have any more breaking developments, we will be updating our blog, sending out alerts, and depending on the nature of the update, holding another webinar. Thanks, everyone.